Good day. This is Attorney Season. Welcome again to Criminal Law Book 1. Today, I'll be discussing the circumstances which affect the liability of the offender. So, the following are the circumstances that affects the criminal liability of the offender. So, we have here the jima'a, or the justifying circumstances, exempting circumstances, mitigating circumstances, aggravating circumstances, and alternative circumstances. Okay, so that's from Articles 11 to 15. So let's tackle first justifying circumstances. What do you mean by justifying circumstances, or what is justifying circumstance? So justifying circumstances are those where the acts of the actor are in accordance with the law. Therefore, he incurs no criminal liability. So since there is no crime, there is no criminal and civil liability. So again, please take note that in justifying circumstances, the accused does not commit any crime because the act of the accused is in accordance with the law. Okay? So what's the effect of invoking justifying circumstance? Okay, in criminal cases. So the moment the accused invokes any of the acts amounting to justifying circumstances like self-defense, defense of relative, defense of stranger, fulfillment of a duty, etc., he is in fact admitting the commission of the crime. So he admits killing the victim. But he wanted to evade criminal liability. That is why he is invoking justifying circumstances. Why? Because if you will invoke justifying circumstances, the accused will not incur criminal liability because in justifying circumstances, the accused does not commit any crime because the acts of the accused is in accordance with the law. Okay? So, Article 11, the following do not incur any criminal liability. Number 1, anyone who acts in defense of his persons or rights, provided the following circumstances concur. Number 1, there should be unlawful aggression. Second, there should be a reasonable necessity of the means employed to prevent or repel the said aggression. And third, the last element, is the lack of sufficient provocation on the part of the person defending himself. So paragraph 1 speaks of self-defense. And element number 1, unlawful aggression. What is unlawful aggression? This means actual assault or threatened assault, provided that it is immediate or imminent in kind, meaning the assault is at the point of happening. It is imminent. It is immediate. Okay? And unlawful aggression, take note, does not include mere threatening or intimidating attitudes, such as when a person will say that, I will kill you. Okay? Tomorrow I will kill you. Tomorrow I will have my day. Or later, okay, I will take my gun and shoot you. Okay? So that's a mere threatening or intimidating attitude only, and that will not constitute unlawful aggression. For it to constitute unlawful aggression, there should be what? Actual assault of immediate nature. Okay? And please take note that unlawful aggression must come from the person who was subsequently attacked by the person defending himself. So the aggression or the unlawful aggression must come from the victim, not from the accused. So the person defending himself must not attack a person other than the unlawful aggressor. Okay? So example, A attempted to stab B. So B, in his defense, stabbed Mr. C. And Mr. C is A's companion. Now, was there self-defense? The answer is no. Why? Because the facts did not show that C was a conspirator or accomplice of A in stabbing B. Okay? C was only A's companion. There was no conspiracy between A and C. Therefore, B should be criminally liable because he stabbed a person other than the unlawful aggressor. So the unlawful aggressor was letter A, not letter C, A's companion. Okay? So again, the unlawful aggression must come from the person who was subsequently attacked by the person defending himself. And the person defending himself must not attack a person other than the unlawful aggressor. Another example. So Mr. A attempted to stab Mr. B. Mr. B, in his defense, stabbed letter C. And C is Mr. A's companion. So previous to the incident, A and C attempted to corner B in an alley. So there's conspiracy now that A and C, okay, will attempt to harm Mr. B. No question, was there self-defense? The answer is yes, because based on the collective acts of Mr. A and C, they were conspirators in attempting to kill B. And if you're a conspirator, the act of one is an act of all. Again, if there's a conspiracy, the act of one is an act of all. Number 3, A attempted to stab B. B, in his defense, also attempted to stab A. However, A dodged B's attempts. So B was able to stab C, the man behind A. Now, was there self-defense? Take note that B was able to stab C, the man behind A. Now, was there self-defense? Definitely, the answer is yes. Why? Because B merely defended himself from the unlawful aggression of A. And he actually aimed at A. Therefore, even though C suffered injuries, B cannot be held criminally liable. Why? Because the accused, or letter B, merely defended himself. He acted by virtue of self-defense. And always remember that in self-defense, the accused or the actor does not incur any criminal liability. So the requisites of self-defense are without prejudice to the proper application of mistake of fact. And mistake of fact is an absolute cause. Example, in the case of United States versus Achong. So due to the rampant criminality within the community of Achong, Achong thought that the person who went inside his room was a robber and not his roommate. Therefore, there was a mistake of fact. There was a misapprehension of facts that his roommate was an unlawful aggression. So the moment Achong injured his roommate, the supposed to be unlawful aggressor, he committed no criminal liability because he acted by virtue of a mistake of fact. And mistake of fact is an absolutory cause. Therefore, he is relieved from any criminal liability. Number 2, example. A pointed a gun at B. So B shot A. It was later revealed that Mr. A merely pointed a toy gun at B. Did B commit any crime? The answer is no. Why? Because there was mistake of fact that A was an unlawful aggressor. B believed that A pointed a real gun at him. However, it was revealed that it was merely a toy gun. So there was misapprehension of facts. Okay? Mr. B, they thought that his life was in danger, and he thought that Mr. A was an unlawful aggressor, or that there was an unlawful aggression. Therefore, he cannot be held liable for the death of A because there was a mistake of fact involved. In other words, honest belief, or if the accused acted in good faith, it has the same effect as mistake of fact. Okay? So, mistake of fact is an absolutory cause. You will not incur criminal and civil liability. So, retaliation is not self-defense because the unlawful aggression has already ceased. So, if ever si A, okay, is the unlawful aggressor, and B, okay, is the one defending himself, and then A retaliated, and then B retaliated. Therefore, during the retaliation, the unlawful aggressor is the retaliating person. So take note that the person who retaliated is not acting in defense of his person. He is actually acting as the new unlawful aggressor. And the person he is retaliating to is the one who can invoke self-defense. Why? Because there is the unlawful aggression ceased. Okay? The moment there's a retaliation. So in case the person who retaliated gets injured or dies during the retaliation. Say for example, okay, letter A, okay, the unlawful aggressor attacked B. Okay, the one acting in self-defense. And then, okay, A was unsuccessful. So A retreated. However, B, okay, attacked Mr. A in retaliation. Libalo siya. Okay? Now, can he be held liable for the death of A? Definitely yes. Why? Because he cannot invoke anymore self-defense. Why? Because in retaliation is not self-defense. Again, retaliation is not self-defense. Mobalos ka and wala na yung unlawful aggression, okay? It cannot be considered as a self-defense because retaliation is not self-defense. Because the unlawful aggression, okay, has already ceased. Ni-stop naman. Why si A, ni-back out na. Then ikaw, imong gi-atake. Wala na yung unlawful aggression kang gi-protect. Therefore, during retaliation, the unlawful aggressor is the retaliating person. Ikaw nanuoy unlawful aggressor. And the person who retaliated, ang libalos, is not acting in defense of his person. Why? The unlawful aggression has already ceased. He is actually acting as the new unlawful aggressor. And the person he is retaliating to is the one who can invoke self-defense. So if ever nibalos ka, then si Mr. A, ikaw si Mr. B, nibalos ka, si Mr. A, gi-repel niya ang aggression, nisukol siya nimo, uy, then matay ka. He can invoke self-defense. Why? Unlawful aggressor naman ka. Okay? So, again, retaliation is not self-defense. Second principle, when the aggressor flees, okay, di-back out. Di-back out ang aggressor. Nadlook. Okay, tigbason unta ka niya, paana, wala siya kaigo, dalagan lang siya, nadlook siya. So, unlawful aggression no longer exists. Hence, the one making the defense has no more right to attack the former aggressor. Once mo flee na ang imong aggressor, dili na nimo pwedeng lamton kung yun. Why? because the unlawful aggression is gone. Okay? It no longer exists anymore. Why? Ni-flee naman si aggressor. And if ever muataka niya, that's not self-defense anymore. Okay, you can be held liable for that person's death. But there's an exception. If the purpose of the aggressor in retreating, okay, ni-retreat, ang purpose sa pag-retreat kay to take a more advantageous position, let's just say, ni-retreat para mo tago sa kahoy, para silon ka, para di siya sa bala, ni-hide siya, etc. As long as to take a more advantageous position to ensure success of the attack already begun by him, the unlawful aggression is considered still continuing. Again, as a general rule, if the aggressor flees, unlawful aggression no longer exists. Therefore, bawal ka mo retaliate because retaliation is not self-defense. However, if ni-retreat si aggressor to take a more advantageous position, okay, there is still unlawful aggression. Why? Because unlawful aggression is deemed continuing if the aggressor retreating's purpose is to take a more advantageous position. Therefore, you can still attack the aggressor. So there is no unlawful aggression when there is agreement to fight. So as a general rule, if nagsabot mo nga magsumbagay, okay, you cannot invoke what? Self-defense. Why? Because there's no unlawful aggression when there is an agreement to fight. But when there is an aggression ahead of the stipulated time, place, and place of the fight, there is, of course, unlawful aggression. But as a general rule, if there is an agreement to fight, there's no unlawful aggression. And second element, okay, of self-defense, we have reasonable necessity of the means used to prevent or repel the said aggression. So it does not imply material commensurability between the means attack and the defense. So what the law requires here as a reasonable necessity of the means used to repel or prevent the unlawful aggression is rational equivalence. Okay, according to People versus Encomienda, what the law requires is rational equivalence. So, for example, ang knife is rationally equivalent to a gun. Why? Because ang knife, makapatay. Ang gun, makapatay. So, there's rational equivalence. Another one is a piece of wood and a knife. Why? Kaya if bunalon ka sa ulo o wood, makapatay na siya. And if dunggabon ka, makapatay pa na siya. So, there's rational equivalence. And also, piece of wood and gun. There's rational equivalence. And then steel pipe and gun. Okay, so again, knife is rationally equivalent to a gun. Piece of wood is rationally equivalent to a knife. Piece of wood and a steel pipe is rationally equivalent of a gun to a gun. Why? Because all these objects can kill. And hands are not rationally equivalent to a knife. Why? Because hands cannot kill unless you are a professional boxer. Diba? But if you're not a professional boxer, okay, like Manny Pacquiao, there's no rational equivalence. Okay? So always remember that hands cannot kill unless if you are a boxer like Manny Pacquiao. In People versus Luage, an attempt to rape a woman constitutes an unlawful aggression sufficient to put her in a state of legitimate defense. So if a woman is being raped, he can what? Defend herself. And that's what you call defense of honor. Okay? So in as much as the woman's honor cannot be esteemed as a right, as precious, if not more, than her very existence. Hence, the woman imperiled may kill her offender if that is the only means left for her to protect her honor from so grave an outrage. Therefore, if the woman is raped, he can invoke defense of honor. Okay? Last element is the lack of sufficient provocation on the part of the person defending himself. So always remember that the provocation is sufficient when it is proportionate to the act of aggression and adequate to steer the aggressor in committing the act. So sufficient provocation, imo gihagit o sumbagay ang usa ka tawo. Imo siyang gisultian og mga harsh words to steer the aggressor in committing the act. Okay? So there are instances when the third requisite, meaning lack of sufficient provocation on the part of the person defending himself, is present in favor of the accused. Okay? So as a requirement, there should be a lack of sufficient provocation, meaning, number one, the accused made no provocation at all. If the accused made no provocation at all, he can invoke self-defense. Or where the accused, okay? Accused meaning the person who defends himself, made an insufficient provocation, he can invoke self-defense. But if he will invoke sufficient, but if he will commit sufficient provocation, sufficient and adequate to steer the aggressor in committing the act, he cannot invoke anymore self-defense. Why? Because in self-defense, there should be lack of sufficient provocation on the part of the person defending himself. And number three, where there was sufficient provocation, but it was not given by the accused. Okay, so these are the instances when the third requisite is present in favor of the accused, in favor. Now we have here clear and convincing evidence. So in criminal cases, especially if the accused alleged justifying circumstance, the prosecution must prove the accused guilt beyond reasonable doubt. But if the accused alleged justifying circumstance, such as self-defense, he must show by what? Clear and convincing evidence that all the elements of self-defense are present. Okay, what are the elements of self-defense? We have unlawful aggression, reasonable means employed to prevent or repel said aggression, and lack of sufficient provocation on the part of the person defending himself. So the accused in invoking self-defense must show by clear and convincing evidence all the elements of self-defense. What do you mean by clear and convincing evidence? So it is defined as the quantum of proof that is greater than preponderance of evidence, the greater weight of evidence, but less than proof beyond reasonable doubt. Always remember that in criminal cases, you can only convict a person as long as there is proof of guilt beyond reasonable doubt. In civil cases, there's preponderance of evidence, meaning greater weight of evidence. So, patas-anay sila og evidence. So, for example, in a land dispute, person A has a deed of sale, while person B has a certificate of title. Now, who will win? Of course, the one who has the title, the land title. Why? Because in civil cases, the quantum proof only required is the preponderance of evidence, meaning the greater weight of evidence. But sa anay ebidensya. And then, of course, clear and convincing evidence must be lower siya sa proof of guilt beyond reasonable doubt. Okay? Again, clear and convincing evidence. It is greater than preponderance of evidence, but less than proof beyond reasonable doubt. So not just middle. Number two, okay? So this is what you call defensive relative. So anyone who acts in defense of the person or rights of his spouse, okay? Mga asawa, descendants, mama, papa, lolo, descendants, anak, your brothers or sisters, whether legitimate illegitimate or adopted, or your relatives by affinity, meaning relatives by marriage, and relatives by consanguinity, meaning relatives by blood, like your aunt. Okay, relatives by affinity, your father-in-law, mother-in-law. Okay, you are related only by marriage, relatives by affinity, while in relative by consanguinity, meaning you are related by blood. So, provided that the first and second requisites prescribed in the next preceding circumstances are present. So there should be what? Unlawful aggression and lack of and reasonable means employed to prevent or repel the said aggression. And in case the provocation was given by the person attacked, that the one making defense had no part therein. So defense of relative, who are relatives? So we have your spouse, ascendants, descendants, brothers or sisters, relative by affinity, and relatives by consanguinity. Okay, like first cousin, uncles, nieces, uh, and for the third requisite, okay, very important, it's different. It states that in case of provocation was given by the person attacked, that the one making the defense had no part therein. So this means that there is still defense of relative, even if the relative provoked the unlawful aggressor, as long as the accused had no part therein. So that's a requirement, as long as the accused had no part therein. So example number 1, B stabbed A. In defense of A, his son shot B, yung anak. Now B died. Is the son criminally liable? The answer is no. Because the son, what? Acted in defense of a relative. He defended his father. Second example, A shouted demeaning and racial slurs. Okay, at B. So in short, A provoked B. There was provocation, sufficient provocation. So B stabbed A. Kaya naglagot man. So in defense of A, iyang anak gipusil si B. And B died. Is the son criminally liable? The answer is no again. Why? Because the son acted in defense of relative. So even though A provoked B, A's son had no part in the provocation. And that is a requirement. Okay? The requirement that the accused had no part therein. Ang accused there is son. Yeah, wala mo siya part ato. Therefore, not liable. What if the shooting? What if in shooting B, the son was also motivated by revenge, resentment, or evil motive? Gilagot po siya ba? Okay, mo na ni Balos. So, revenge, resentment, and other evil motive are immaterial. It's not important. Okay, in defense of relative. As long as the son of A did not provoke, as long as wala nag-provoke ang son, there is still complete defense of relative. It does not matter if the son of A and B are mortal enemies. The son still incurs no criminal liability. Number 3, paragraph number 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present. So very important ang first and second requisites or elements. And that the person defending, okay, take note that the person defending be not induced by revenge, resentment, or other evil motive. So, in short, this paragraph is known as defense of stranger. So, any person not included in the term of relatives is a stranger, like your step sibling, step parents, uncle-in-law, cousin-in-law, nephew-in-law, second cousin, and third cousin. So the first two requisites are the same as self-defense, unlawful aggression, and reasonable necessity of the means employed to prevent or repel the said aggression. But as for the third requisite, the person defending must not be induced by revenge, resentment, or other evil motive. Example, A shouted racial slurs at B. So B stabbed A. Okay. So being a witness to the incident, X shot B because they were mortal enemies. Okay. So A and X were friends. Is there a complete defense of stranger? The answer is no. Why? Because X was induced by revenge, resentment, or other evil motive when he shot B. Therefore, he is criminally liable for shooting B. So take note of the third requisite. The person defending is not induced by revenge, resentment, or other evil motive. Because if the person defending is induced by revenge, even resentment, or other evil motive, he can be held liable uh, for such crime. Another example, A and X shouted racial slurs at B, so B stabbed A. Being a witness to the incident, X shot B. X and B are not mortal enemies. A and X are friends. Is there a complete defense of stranger? So number one, okay, provocation. Always remember that provocation is immaterial in defense of stranger. Therefore, X incurs no criminal liability. As long as X was not motivated by revenge, resentment, or other evil motive, there's still a complete defense of stranger. So it does not matter if X provoked B. Therefore, X incurs no criminal liability. Okay, in this scenario. Number four, this pertains to the avoidance of an evil or injury. So any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided the following requisites or elements are present. First, the evils sought to be avoided actually exist. And then the injury feared be greater than done to avoid it. And there be no other practical and less harmful means of preventing it. So one good example is this case. Okay? So a pregnant woman met an accident. She was immediately brought to the hospital. Because of the said dire situation, the doctor who was in charge of the pregnant women has to make a decision. But is to save only one life, either the woman or the baby that she is carrying. So the doctor chose to save the life of the woman. Because of that, the fetus died. He was prosecuted for abortion. The doctor invoked the doctrine of state of necessity. Now, is the doctor liable for abortion? The answer is no. Why? Because the elements of state of necessity are all present. Always remember that paragraph 4 is known as state of necessity. Number one, the elements of state of necessity are all present. Number one, the evil sought to be avoided actually exist because the life of the baby and the mother is in danger. So there's an evil that is sought to be avoided. Second, the injury, meaning the death of the pregnant woman, is greater than the death of the fetus. And there was no other less practical or harmful means of preventing it. Okay? Because what? The situation was an emergency. So the woman had no relatives with her. So the doctor decided immediately either to save the life of the mother or the fetus. So in this case, the doctor should be absolved from criminal liability by virtue of state of necessity. And number 5 and 6. So any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office And any person who acts in obedience to an order issued by a superior or some lawful purpose. So we have here the means to carry out the order. The order is also lawful. So, example, PO3A obeyed the order of Colonel B to sell the dangerous drugs that they seized from the recent trade. He sold the same to drug addicts. Later, PO3A was charged with violation of the CDDA, the Comprehensive Dangerous Drugs Act. Does PO3 incur criminal liability? The answer is yes, because there was incomplete obedience to superior order. PO3A obeyed an unlawful order from a superior. Always take note that any person who acts in obedience to an order issued by a superior must be for some lawful purpose. The order must be lawful. So in this case, PO3A incurs criminal liability. So take note of that. Obedience must be to a lawful order. There should be a lawful purpose, not an unlawful purpose like selling drugs. So, example, so X was convicted by final judgment for the crime of homicide. When X was about to be transferred to a maximum security prison, he suddenly escaped. Eskapo siya. Police officer Y was ordered by the jail warden to retrieve X. Y thereafter pursued X. Knowing that he was being pursued, X went to a market and grabbed a 5-year-old child as hostage. X pointed a knife towards the neck of the child and he told Y not to pursue him. Otherwise, he will kill the child. However, the child cried. The crying child started to annoy X to the point that he was about to kill the child. However, sensing that X was about to stab the child, X fired a shot towards X. X suffered a mortal wound and thereafter died. Y was charged with homicide. Now, what defenses can Mr. Y utilize? So Y can make use of a justifying circumstance of performance of fulfillment of a duty or in a lawful exercise of office because he is a police officer. So as a police officer, Y acted in the performance of his duty in pursuing X, an escaped convict. Likewise, the injury caused to X was the necessary consequence of the fulfillment of Y's duty. Otherwise, X will kill the child. So, and also, Y can also use the justifying circumstance of defense of stranger. Iya man gidefensan ang child, which is a stranger because di man na relative ang child. So, notes, okay, so in self-defense, it is not limited to one's life only. It includes defense of life, defense of your honor, like if a woman is being raped, he can defend himself and he can invoke defense of honor or chastity. And if ever na musulod sa inyong balay, then i-atake ka, you can kill that person. But and that's what you call defense of property. But always remember that in defense of property, there should be what? It should be coupled with an attack on the person entrusted with the said property. Or dapat i-atake ang tag-iya sa balay. Okay? So defense of property provided there that it is coupled with an attack on the person entrusted with the said property. So if nisulod sa balay, dinulay attack, of course you can kill, you can be held liable for the death of such person. And notes about unlawful aggression, it's an attack using physical force like with a weapon, like you're shooting someone, you're attempting to stab someone. Okay, that's an unlawful aggression. It is actual and imminent or at the point of happening. Okay? Okay, here. So there are two kinds of unlawful aggression here in my notes. So we have the actual aggression. It means there's an attack with a weapon or using a weapon. It's an offensive attack that positively determines the intent of the aggressor to cause the injury. Like tigbaso ni mo sa katawo, dunggabon, pusilon. Okay, there's an actual unlawful aggression. Then imminent unlawful aggression, meaning the attack is what? Impending or at the point of happening na. Hapit na ba? Oh, okay? Tigbaso na ka, padulong na ang kuan mo. Oh, imminent unlawful aggression. Padulong na ang blade weapon. So that's an imminent unlawful aggression. And stand ground when in the right. So what's the reason behind the self-defense? So the reason behind self-defense, stand ground when in the right, means that where the said accused is where he should be and his assailant is fast approaching, the law does not require him to retreat. Okay? Because if the moment he retreats, of course, he runs the risk of being stabbed at the back. If magkatalikod ka, dalagan, abutang ka ba na noon ka? So dapat mo depensahan imong self. So you have the right to defend yourself. And battered woman syndrome. So it refers to a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships. Okay, under RA 9262. So what's a battered woman? Under Republic Act 9262, the Anti-Violence Against Women and Their Children Act of 2004. So a battered woman is a woman who is repeatedly subjected to any forceful physical or psychological behavior by a man in order to coerce her to do something he wants to her to do without concern for her rights. For example, if ang husband kulataw niyang wife, that's physical abuse. If ang husband mangabit, that's psychological abuse because that's marital infidelity. And battered woman includes wives, asawa, or mga dating relationships. Okay? And you should take note that in order to be classified as a battered woman, the couple must go through the battering cycle at least twice. So, muna siya cycle of violence. So, in order to be classified as a battered woman, dapat niagi siya ni og twice. So, in the case of People versus Hinosa, the Supreme Court held that the battered woman syndrome is characterized by the so-called cycle of violence. We have here the tension-building phase, the acute battering incident, and the tranquil-loving phase. So, in the tension-building phase, katara mga minor battering occurs, mga verbal abuse, slight physical abuse, may ana ra. Tension-building ba, ga-build pa. Okay? But pag acute battering incident na, brutal na, and might cause death. Okay? So this is characterized by brutality and destructiveness. Ang nagabunog na ang imong wife. Okay, imong kulatahon. So acute battering incident na, it is severe. It is brutal and destructive. And in the tranquil or loving phase, okay, so the couple experience profound relief on the one hand, and the batterer may show a tender and nurturing behavior towards his partner. He knows that he has been viciously cruel and tries to make up for it. So, may napagpasaylo ang batterer. Okay, ang husband may pasaylo for forgiveness and mo promise nga di na niya buhaton. So that's the tranquil or loving phase. So if in order to be classified as a battered woman, dapat moagi siya og at least twice an tension building phase, acute battering incident phase, and the tranquil loving phase. Okay? So in battered woman syndrome, it's like justifying circumstance. It is even better than self-defense because in self-defense you have to prove elements. Okay, 3 elements: lawful aggression, reasonable means employed to prevent or repel the said aggression, and lack of sufficient provocation on the person defending himself. But in battered woman syndrome, what should be proven is that the wife is suffering from battered woman syndrome. And it is true, the expert testimony of a psychiatrist will prove that the wife is suffering from battered woman syndrome. And if this is proven, she is absolved from criminal and civil liability. Okay, so that's all for now. Thank you for listening. God bless.